Welcome to Mayor Brown's Tech Talks podcast. Each podcast is designed to provide insights on legal issues relating to technology transactions and keep you up to date on the latest trends in data, digital, outsourcing, and software by drawing on the perspectives of practitioners who have executed technology transactions around the world. You can subscribe to this series on all major podcasting platforms. We hope you enjoy the program.
Hello and welcome to Tech Talks. Our topic today is software and data audits, tips to avoid the traps. How can licensees reduce the risk of audits from software and data licensors? We'll talk about why these are a hot topic, some common issues, and how audits get settled. We'll also provide advice on negotiating audit clauses. I'm your host, Julian DeBell. I am a senior associate in Mayor Brown's technology transactions practice. I'm joined today by Rich Asmus, a partner in our intellectual property practice, Brad Peterson, a partner in our technology transactions practice, and Jenge Tamba, an associate in our technology transactions practice. Rich, let's start by framing the question for everybody. What is a software or a data audit?
Thanks, Julian, and hello to everyone joining us. Audits can be ordered by a court, but we're going to talk today mainly about contractual audits, audits that are called for in a contract between a licensee and their software or data vendor. And those audit clauses can vary widely in scope, but generally allows the vendor to consider whether or not their licensee is in compliance with the terms of that license. Are they using it on the right types of computers? Are they using it with the correct number of named users? Are they using the software in the right locations? There may be limitations on the permitted use of the software as well, and an audit clause would typically give the licensor vendor the right to audit that. In connection with data licenses, they might also be permitted to audit the use of the data, including what we call indirect use or derived use of the data. Those are instances where the data is not used directly, but is used in some transformed manner, for example, to do a calculation. These audits are often presented not as a formal audit, but as an optimization project. It might go not to the legal department, but to someone that the sales associate for the vendor has a contact with. It might, for example, be presented as an opportunity for savings. Let us take a look at the way you're using the software, and we'll find out some ways you can save money. And oftentimes these audits are tied to a quarter end or a year end. The methods of the audits can also vary widely. They can be done on written questions and answers. They can involve running a script at the licensee side to determine the use of the software or the use of the data. They can involve on-site visits by the vendors, and they can involve all of the above in sequence or in order. These audits often take many, many months and sometimes even years to conclude.
It sounds like that could be burdensome, to say the least. And might also involve risk of increased payments. Why do these audits occur, Brad?
Julian, you're right about the audits being a risk to licensees. We have seen our licensee clients asked by software vendors for amounts that are far in excess of their spend on licensed software and data. And there's no one reason for the audits, and it's possible that the licensee's number just came up in a program of random audits. But there are three primary patterns that we see. The first is there are some contract terms that regularly pay off in audits. And if you think about a licensor running a business, they have extensive experience testing audit theories with some clients, and many of those work consistently. Thus, we at Mayor Brown see many of the same theories from the same software vendors over and over. In fact, some of these audits have become a regular revenue driver for some licensors, allowing them to consistently sell the next generation of their products to solve problems detected in audits. And the licensor's ROI on these audits is being improved constantly as big data tools allow the licensors to search for violations in new ways at less cost. So first is contract terms that regularly pay off. The second is trigger events. As Rich said, the licensor's sales team is maintaining close connections with the licensee and monitoring licensee activity. So if there is merger and acquisition activity, if there are requests for consents for an outsourcing, or if new products have been announced by the licensee as part of its own digital transformation or cloud transformation, that might be a trigger event for an audit. And then third, there's suspicion of compliance problems. The suspicion may arise from past compliance issues, or it may arise because the licensee has known weaknesses in its software asset management or data asset management systems. Also, because of coincidences that are just hard to explain otherwise, information about audit rights appears to be shared by some licensors between themselves or by the independent auditors that the licensors use. So a client that faces an audit from one vendor might see follow-on audits on similar theories from other vendors.
Well, none of that, what you've described, Brad, seems to favor the licensee. Jenge, can a licensee just say no to an audit?
Unfortunately, that's rarely an option. Vendors have leverage because they could sue licensees and use discovery rights to get this information. However, that is rare because license agreements generally don't express the right. For example, a licensor's form might state that upon 10 days written notice, licensor may audit your use of the programs. You agree to cooperate with licensor's audits and provide reasonable assistance and access to information. You agree to pay within 30 days of written notification any fees applicable to your use of the program and access of your license right. If you do not pay, licensor can end your technical support licenses and/or this agreement. Licensees often seek to negotiate these clauses. For example, they might seek to extend the notice period, narrow the scope, reduce the obligations to cooperate, and provide discounted rates for overusage. The licensee may be able to get a remote question and answer process instead of an on-site audit, or a right to fix good faith efforts. However, a licensee rarely gets a license agreement that actually prohibits an audit. So refusing to allow an audit may be a material breach, allowing the vendor to terminate the license.
Okay, so the licensee needs to deal with the audit. Rich, what should a licensee do first internally when they're facing down an impending audit?
So it's very important that it be managed as a project and not as an on an ad hoc basis. We recommend that licensees appoint a single point of contact and establish clear lines of communication. That's in contrast to having every single person in the organization, from the CIO down, talking to the vendor individually. In addition, we want the legal function, the legal team, either in-house or external, to be involved in the audit in a way that preserves, to the maximum extent possible, privilege over the investigation. And that involves a couple steps. One is to make sure that documents that are collected are processed in a thoughtful manner, sent to attorneys first, not exchanged among the business team. And the legal team will want to train the audit team on communications. We're not suggesting that the lawyers need to do all the talking in connection with the audit to the vendor. In fact, just the opposite. Oftentimes, the business people are in the best position to communicate. But the audit team does need to have clear direction from the legal team about what to say, what not to say. They need to understand that anything they say to the vendor can come back to hurt them if the matter unfortunately goes to litigation. In addition, the legal team will want to ensure that documents and data are preserved. The worst position to be in is after a lawsuit is filed to find out either that evidence that was exculpatory has been destroyed, or even worse, that evidence that might be helpful could be involve an inference against you if you fail to preserve it. Finally, on this point, we want to make sure that the audit team avoids finger pointing. There's no need to break ranks. There'll be plenty of time after the audit is settled to do a post-mortem to figure out what went wrong.
Okay, so aside from giving guidance to the audit team, then what should the legal team itself be focusing on?
So the legal team needs to take a clear-eyed view of what the leverage factors are, both on their side and on the vendor side. On the licensee side, the legal team needs to assess the risk that there's actually a non-compliance. Just because there's an audit ordered or an audit set, it doesn't mean that you're not in compliance, but you do need to get an early view of whether or not there are compliance issues. And we'd point out that with respect to data, the infrastructure may not exist to track that use, unlike in the software realm, where typically IT departments are tracking named users. In the data front, that may not exist. The client should consider the legal risks, the financial risks, what it would mean to the budget if they needed to accede to the audit demand. Also, the legal team should determine what are the options to clean up, and it's always better to do that early. And then finally, the client really needs to understand the product dependency. Is this a license that they could terminate, that they could threaten to walk away from, or is it a license that's so intertwined with other business functions that there's really no effective way to terminate it? We see that a lot in the ERP realm, where the vendor really has a huge advantage over the licensee because the software in question really runs the licensee's entire business. And then finally, you need to get a very solid understanding of the legal documents that govern the relationship with the vendor.
Well, yeah, understanding the legal documents is, of course, a core legal function, but we see that it's often surprisingly challenging. Jenge, what does the licensee have to do to understand its rights?
Julian, there are 3 steps that the licensee can take to understand its rights. The first step is to collect the relevant documents, which includes the contracts, the purchase orders, invoices, earlier audit reports, settlements, pricing lists, and correspondence. This is, as you say, often surprisingly challenging, and good organization can be quite helpful here. The contractual framework often consists of multiple layers of contracts and incorporated terms. In many cases, our clients struggle to find copies of all their documents. The pricing model may be complex and may separate from the license itself and be found in price lists, order forms, and other documents. We at times see questions of enforceability with respect to new terms communicated to licensees but not actually signed. Once you have the contracts, the second step is to then review and extract the relevant clauses. These include, for example, the audit clause, the license grant, under licensee obligations, which are contractual obligations to true up your license at the rates then in effect, and the liability regime. The third step is to analyze actual system and usage data compared to the license language. This is often a team effort with legal, operational, technical, and procurement involved.
Thanks, Jenge. So, Brad, once you've done all that contractual analysis, does that just give us an answer?
No, unfortunately, it often does not just give us an answer. License drafting is often ambiguous, particularly in order forms reviewed only on products and prices and some of the other supplementary document. But even licenses that were clear when they were written might be ripe for dispute as technology changes. I talked earlier about some clauses that are successful for vendors a lot of times. Let me give you 2 quick examples of how technology is running right past the license language in old agreements. First, virtualization. Let's say that a license permits use of software on one server. Using virtualization technology, the licensee can run the software in one virtual server. And to the software, the virtual server looks just like a physical server. But the virtual server might run on many physical servers. And if the virtual server is in the cloud, it might run on hundreds of physical servers as workload is reallocated in the cloud. The licensee, of course, would say that the software is still running on one server. That's the amount of computing power that's being used with the software. But some licensors in audits claim that the software is running on all of the physical servers that hosted the virtual server. On that theory, they propose an enormous charge for excess server usage. Let's take a second example, robotic process automation, or RPA. Let's say that the license is for 10 users and that the licensee once had 10 human users with 10 user IDs who were keying in queries for 500 managers into the software. Then using RPA, the licensee replaced those 10 human users with RPA bots. And those RPA bots took input from managers through a portal and submitted the queries to the software. So the 10 user IDs went to the bots who act just like human users, but so much faster. The licensee would say that nothing has changed. There's still only 10 user IDs in use, and the same work is being done for the same 500 managers for the same enterprise. If anything, the licensee might say, look, I'm now using 0 users if you're talking about human users. But some software vendors claim that each of the 500 managers who's working through the bots is an indirect user of the software through those bots. And on that theory, the software vendor claims that the licensee needs not 10 user licenses, but 500 user licenses, one for every manager with access. Some courts have even agreed with that theory. This obviously can get contentious. Some licensees believe that the software vendors saw these technology changes coming before the licensees did and set traps for unwary licensees. Some licensees believe that the licensors are just grabbing revenue for innovations that are created by other companies like the virtualization companies and the RPA companies. Licensors, of course, fiercely object, arguing that the new usages with virtualization and RPA and other technology provide new value to the user, to the licensee, beyond what the licensee bargained for in the license agreements.
Okay, so it sounds like the licensee may be going into a somewhat adversarial process with the software vendor. Rich, you have plenty of experience in dispute resolution, including in litigation and arbitration. What do you advise in a situation like this?
We advise that licensees treat each audit as if it could end up in litigation. The fact is that most audits don't end up in litigation. They end up being settled in some manner. By preparing for litigation, you're showing the vendor that if push comes to shove, you're willing and able to win that litigation. Another recommendation is not to be rushed, to always try to buy time in the audit. The vendors will tell you that they have some strict deadline, whether it's quarter end or year end or what have you, and you should take all those deadlines with a grain of salt. The fact is, the vendor is going to be happy to get some money whenever they get that money, and the deadlines, in our experience, are basically artificial. You should make sure that you have a good non-disclosure agreement in place. If the agreement itself doesn't have strict confidentiality rules, you also want to make sure that if you are being asked to install an audit tool, you have protection if that audit tool causes some damage to your system or there's other problems with its installation and use. It's also often a good idea to get some friends, so to speak, involved in the audit, whether that be an integrator that helped you manage the project of implementing the software, maybe even a reseller. Oftentimes, the reseller has made admissions to you about the way that you can use the software that the software vendor itself may not be aware of, but that the vendor will be charged with by way of that reseller acting as an agent for the vendor. You should also challenge every assumption, every fact that the vendor tells you, and always ask them for proof. They may tell you that this is their pattern and practice. When it isn't, they may tell you that they always act in a certain way when they don't. And you should see if you can figure that out. You should also evaluate the credibility of the threats they are making. They might threaten to discontinue support. They might threaten to file suit. They might threaten to cut off various services. For example, if the software is used through the cloud, they might threaten to cut off that access. So you should determine the credibility of those threats by checking the litigation history, checking the background of the people that you're involved with on the vendor side, looking at press reports about actions or litigation. In addition, user groups are often a very good resource for dealing with audits, as both informal and formal. The issues many of our clients are having, in fact, recur with each of the vendors. Clients have common architectures, common issues, and you can learn a lot by determining, to some extent, how the vendor has settled similar disputes.
Well, thanks, Rich. It sounds like you walk into the negotiation well prepared. Brad, what do you see walking out when it comes to the settlement phase?
Well, what you see in the settlement depends on the facts, of course, and many of the things that Rich just talked about. What are the audit findings and the technical basis for the allegations? How strong are the vendor's contractual claims after the review? How strong is the evidence of overuse after your review? What other evidence has been pulled up? A big one is, how much do the parties care about a good future relationship? Is this an end of life, or is this a relationship that will grow and flourish with a lot of revenue and value going both ways? And finally, whether the audit was used purposefully to perhaps sell a newer replacement product. If the audit was sold with the intent to move the customer to the next generation, the audit very often results in the customer on the next generation. In terms of settlement terms commonly include some sort of a payment for the licensor. However, an 80% reduction from the initial ask is not unexpected, and in many cases there is no payment. You often see an increased, or almost always you see an increase in license levels to reflect at least the usage levels that were established in the audit. There's also a full release for the licensee for claims based on past events, with the licensee making no admission of past liability. And there may be some sort of a grace period for the licensee before any future audits from the vendor. And finally, generally, when we get to the end of these, there is a better agreement.
Well, I like the idea that the parties walk away with a better agreement, but curious what specific terms would we want to see in a better agreement? Jenge, what would you look for?
We generally work first to make sure that whatever went wrong does not go wrong again. So, for example, in the license grant, we do this by adjusting the licensing regime. We modify the number or types of license units. So, for example, changing the license metric from users or CPUs to transactions, employees, or customers. Alternatively, the problem might be addressed by removing limits and having a corporate-wide license. Second, we clarify terms that cause disputes or have the potential to cause more confusion. And we prepare for change with discounts for additional purchases, a right to swap licenses between products or other approaches, or to compensate under licensing with over-licensed products. In addition, we may revise the audit clause. If there were any painful parts of the audit, we seek to address those through revision. For example, we might increase the notice period and reduce the intrusiveness.
So, Rich, I think you probably have the best sense of the full dimensions of this phenomenon here. What do you have in the way of closing thoughts on this topic for us?
As I mentioned, you need a clear-eyed view of the leverage points. And one thing we've observed is the most dangerous auditor is a vendor that's being replaced for one reason or another, because you've moved on to other software or because the software is no longer used in the same way. Any of those instances where the vendor in question is essentially a legacy vendor, the chances of a protracted and expensive audit are much greater because you really have no commercial leverage over that vendor. The audit may be the last time for that vendor to squeeze any money out of you as the customer. That can also happen even with a vendor with whom you have an existing and future relationship if they're trying to squeeze the last dollars out of a software product that's reaching end of life and is about to be sunsetted. So our advice is to pay particular attention when you lack other commercial leverage over your vendor.
Well, thank you, Rich. And thank you, Jenge and Brad, for all your insights today. Listeners, if you have any questions about today's episode, or if you have an idea for an episode you'd like to hear about anything related to technology, transactions, and the law, please email us at techtransactions@mayorbrown.com. Thanks for listening.
We hope you enjoyed this program. You can subscribe on all major podcasting platforms. To learn about other Mayor Brown audio programming, visit mayorbrown.com/podcasts. Thanks for listening.